Welcome back to the channel and thank you for watching. So I am well aware that many people don't quite understand what defamation is, how it might apply, whether it might apply to you, whether you as a member of the public or running a business might be able to claim for defamation and in what circumstances. So in this video I aim to give you a brief overview and to tip you off that there's going to be a couple of interesting videos coming up whereby Mr. Robert Shaw and I are going to dissect a couple of scenarios, giving our opinion a sort of fly on the wall look at how two barristers would discuss and analyse a case, so you can watch that for yourselves. A real case with permission of the person involved, but of course just our views whilst we are not instructed on the case, but our views nonetheless. So welcome back to the channel. I'm a barrister who helps you understand law. So in this video talking about defamation and starting out with some very standard and simple questions that you might ask, such as, first of all, what is defamation? Now whilst there are several elements of defamation in different jurisdictions which differ very slightly, the very broad explanation of defamation is simply a publication which is going to cause damage to the reputation of a party. Sort of actual harm, real harm, and actual damage or financial loss. This of course is taken to be damage to your reputation which causes financial loss in one form or another. Many people talking about both libel and slander, and what is the difference? So first of all, what is libel? Starting out with libel. Libel is a permanent form of publication. Most often this is written material, either in books, newspapers, online, which we'll come back to, but it can also be audio, video, such as television, and so on. But important to note that it can also include something as simple as a tweet, or even liking or retweeting something, or reposting something on Facebook. But in that case, what is, by contrast, slander? Slander, on the other hand, is the spoken word. So it is something spoken by somebody so clearly to one or more people, so other people will hear what you say, and what they say is defamatory. And it can even include some kind of physical gestures. Another very interesting question is, what if I am not named in the publication, and how does that affect my potential claim for defamation? Many people raise the argument as to not being named in the publication. And of course, that was prevalent in the Virginia Depp Heard trial because Johnny Depp was not named in the publication. But the important thing to note here is you do not need to be named in the publication for it to amount to defamation, potentially at the very least. Because if it is clear to the people reading it, even if they are mistaken as to whom that relates, then the article, the publication, can still be defamatory, even if the person is not so named. Next up, what if I just run a company and I think that my company has been defamed? Can my company sue for defamation? It may surprise people to hear that companies can also sue for defamation, usually because they've suffered some kind of financial loss. The one thing the companies won't be able to claim for is damage to feelings, because companies don't have feelings. So that can't become part of the claim, but the financial loss is certainly something that is very serious to be taken seriously. Another common question that arises is, where must the publication be for me to be able to sue for defamation? Online, in print, video, audio? What kind of format must this take? Other people make the mistake of thinking that just because something is online, then it can't be defamatory. And that is, of course, as everyone should know by now from the Virginia trial, that's absolutely not true. If an article is published online, actually it's more prevalent these days that it's going to be seen by a lot more people. So of course, something being published online, it doesn't really matter whether it's in print, in newspapers, online, video, and so on. If it's published, it can be defamatory. Another very valid question is, who would I sue? For example, in the case of Amber Heard, it was Amber Heard that was sued for the defamation, but questions were coming up as to whether it could have been ACLU because they had an involvement in the publication. As to who can be sued for defamation with regard to a particular article, this is a lot more broad than you might think. It includes anyone that was involved in the creation, the publication, and the distribution of said article. This could be anyone involved in contributing to the article, the author themselves, whoever publishes the article, and even the websites and the ISPs, the internet service providers that provide access to or service of that article. They can all potentially be sued for defamation. The next question comes up is, when must I sue, or when am I allowed to sue? And again, this might depend on the jurisdiction. So in other words, is there a time limit for bringing a claim for defamation? The question as to whether there is a time limit for bringing a defamation claim, the answer is yes, and it depends on the jurisdiction, so you really need to check. In England and Wales, it's 1 year. And depending on the state that you are in the United States, it could be between 1 and 3 years. But of course, check out your local jurisdiction for the statute of limitations. The next obvious question is, what are the defenses to defamation? If you are being sued for defamation, what might be a relevant defense to the claim? As for the defenses to defamation, there are really 4 main defenses that are commonly used for defamation. Some of them are statutory, such as in the United Kingdom, there's statutory defense of the truth, i.e. if something is true, then it cannot possibly be defamatory. In England and Wales, we uphold that to be substantially true. So it doesn't have to be proven to 100% truth, just that it's substantially true to make out the statutory defense of the truth. So the truth is fairly universally one of the main defenses to defamation. But also opinion counts as a defense to defamation. Not necessarily a blanket defense. For example, in my opinion, that person is a criminal, a murderer, or so on, if there are no facts to back it up, because that could still defame the person and ruin the reputation without any real grounding in fact. So you can't simply say that's my opinion without any basis whatsoever. However, if you provide some factual analysis or background or basis or some event that's led you to have that opinion, and you voice that as your opinion, that is usually the second argument of defense in defamation. The third common defense for defamation, that is that it's public interest. It's in the public interest for people to know about this fact or opinion or even reason to investigate something. That usually becomes a matter of public interest. Therefore, it is necessary for people to question this, investigate this issue, and therefore it's a defense of public interest. The fourth one is a little bit more nuanced. That is of privilege. So a defense of privilege might be, let's say, for a politician, a member of parliament, or a member of the United States Congress, or something like that, whereby what they say is a matter of privilege, which ultimately means politicians should be able to speak freely because of the office that they hold, and anything they say should be open to question and debate, and shouldn't ultimately be liable for defamation. It is, however, of course, usually qualified. In other words, it's not absolute, meaning that if it was proven to be malicious and simply to defame an opposing party to take them out of a race, for example, that's not then going to stand up as a defense for defamation. Let's say you have a successful case for defamation. Do you get compensation or damages, or what kind of damages might you get? And again, this might depend on the jurisdiction. As to the question of damages, that of course depends on the jurisdiction. In England and Wales, it is normally just damages. There's no sort of compensatory and punitive damages, it's just one set of damages. If you prove that you've suffered serious harm, financial loss, or injury to feelings if you're a person, then you can claim damages as a single remedy, which is an amount of money ordered by the court if you're successful on your claim. If you're in the United States, however, you also have the additional punitive damages to compensatory damages. Compensatory is probably the closest equivalent to England and Wales damages, but the punitive is designed to specifically punish the party for the wrongful act of publishing a statement which is defamatory. Sometimes, however, some people just want an apology for the defamatory or the damaging statement, usually a public apology. Is this possible at court, or is it possible by way of a court settlement? It's a rather interesting question as to whether you can get an apology for defamation, because starting at the end, it's not really the court's job to order somebody to give you an apology, whether public or otherwise. However, as part of a settlement, this is why we often advise mediation and alternative dispute resolution, because you can agree on an apology. You can agree with the person that you're suing that they provide you an apology instead of going to full trial. That can be private, as some people want it, or it can be public, as most people usually require it. It might happen, it might not happen. If it doesn't happen as part of the settlement and that's a deal breaker, then ultimately you might find yourself in court. Some people ask whether or not you have to go to court in order to obtain some kind of redress or compensation for a defamatory statement. And the short answer is no, you don't have to go to court. Simply threatening to go to court over defamation might be enough for you to raise a settlement. I can personally speak for experiences where we've gone to a publisher and legitimately threatened proceedings, and there's been a very rapid settlement because it was quite clear in that case that it was a defamatory statement, because it was a false statement damaging the reputation of the person involved, and thus the publisher involved very quickly came to a fairly substantial settlement for my client without the need to go to court. So you don't always need to go to court. Sometimes legitimately threatening proceedings is enough. But don't take that as a green light to go around starting to threaten proceedings when they are not valid or not founded, because you might find yourself in significant trouble by doing so. Some people ask the question whether you can prevent a defamatory statement being published before it is published, as against preventing a breach of privacy. Now, there are two different aspects here that are very interesting and very important. There is a rule known as the rule against prior restraint, which essentially means you can't usually get an injunction against somebody from making a defamatory statement, or what would become a defamatory statement. This is not to be confused with preventing somebody from breaching your privacy, because if there's privacy, which is usually where there is the necessary quality of confidence about a conversation or a meeting or something else that attracts the quality of confidence, you can very often prevent somebody from breaching that confidence if they've threatened you to do so. Finally, some people might ask, are there any alternatives to bringing proceedings for defamation? As you might have guessed, there are some alternatives to suing in defamation. This could be a malicious falsehood, which is where somebody deliberately, maliciously makes a false statement about you, which in essence sounds very much like defamation, but it's a different type of law and it might attract different damages. It might be slightly easier to prove, and that might be an alternative for you to sue upon. Another alternative might be negligent misstatement, because if somebody is negligent in making a statement which ultimately proves to be wrong, which is what a misstatement is, it's a misstatement of fact, i.e. a statement of fact which turns out to be wrong. If it is made negligently, which is they have some kind of duty of care to you to make sure that it is true, but they don't make sure that it's true, therefore it's negligent and they've broken their duty of care, then it might amount to a negligent misstatement. So that might be an alternative route that you can look at to defamation, which may or may not be easier to sue upon depending on your jurisdiction. So I hope you found this little Q&A interesting. If you have other questions and you have other interests, other areas that you want me to talk about, please do leave me comments in the box below. Remember to like and subscribe to the video. That always helps YouTube to spread this to a wider audience. And as always, thank you very much for watching.